This is the one that, there we go. Good afternoon, everyone. Called to order Section A, Committee of the Whole on Bill 20 to order. Minister, would you like to introduce your staff?
I would. Thank you, Chair. Joining me, Katie Armitage, Legal Counsel, Justice Services Branch, and Carrie Wolf, Legal Counsel, Legal Services Branch.
Thank you, Minister. On Clause 1. Recognizing the Leader of the Third Party.
Thank you, Madam Chair. Thank you, Madam Chair. I just want to start on Clause 1 on the explanatory note. The bill protects access to services of public importance by establishing access zones around certain facilities and prohibiting conduct in those zones that impedes access, disrupts services, or causes individuals concern for safety. The bill has COVID-19 in the title, but no mention of it in the explanatory note. I'm curious as to why that was left out of the explanatory note.
Minister.
Thank you, Chair. The member's question raises a number of interesting issues related to the bill that I would like to run through. The first is that the bill and the protections in the bill are meant to respond to strains in the system that are due to COVID-19. So the public school system and the independent school system and the healthcare system, workers have been, staff, students have been under incredible strain trying to cope with the impacts of the pandemic. And the Access to Services COVID-19 Act, the COVID-19 refers to those strains and our efforts to protect and respond to and ensure that those workers are not and folks who are trying to access essential services are not placed under greater strain. The reason why you don't see it in the bill, for example, in terms of the explanatory notes or the description of the activities that people are engaged in, is the bill is content neutral in terms of the content of the expression that a protester might be raising an issue about. So it doesn't matter what the issue is. If you are intimidating people that are trying to access these essential facilities, if you're intimidating workers at these facilities, it doesn't matter what your message is. We're aiming to protect those workers because of the strain that they're facing. So that's why you see it in the title. But in terms of the behaviors that this seeks to regulate, it is not mentioned. It's content neutral in terms of the expression.
Member.
Thank you, Madam Chair. The impetus for the legislation, as has been in other provinces, has been specifically about responding to protests at healthcare centers, hospitals, and education facilities by people who were opposed to public health measures related specifically to COVID. In the cases of other provinces' legislation, Quebec, for example, the legislation is very specific to COVID-related protests. Why has the minister chosen to expand that when the communication from government around this was that it was related specifically to COVID-19 protests?
Minister.
Thank you, Madam Chair. We've taken a different approach in our province for a couple distinct reasons. One is if you're in an ambulance, you're trying to access a hospital as a patient, you're a worker trying to access a hospital, you're a student trying to access school, or a teacher or a staff member, it doesn't matter to you what the messages of the person who's intimidating you and blocking you from accessing the facility. The impact on your health, the impact on your ability to access the service is the same. And so that is the first reason. The content of the person's message doesn't matter in terms of the mischief we're trying to prevent, which is interfering with someone trying to access a hospital or a testing site or a vaccination site, for example. The second is if you make it content specific, you say, okay, this is about COVID-19, anti-vax, anti-mask demonstrators, then you require law enforcement to do a determination, is this protest actually about that in the moment? And we have heard that even brief delays in people accessing hospital have profound health effects, and asking a police officer to first try to figure out what someone who is clearly already making a decision to interfere with someone's access to an essential service, what the message is and whether it falls within a category of expression that we are specifically targeting is problematic on a couple of different levels. First of all, just for the police officer to make the determination, and secondly, really, what does it matter what the content is if you're interfering with somebody accessing an emergency room? The third is, although we disagree profoundly with the message of the anti-vax protesters and the anti-mask protesters, we think they're wrong on a bunch of different levels, and their message is incredibly problematic, divisive, and unhelpful. We believe they have a right to expression of that, as long as it doesn't interfere with other people's rights to access essential services. This act is about communicating where it's not appropriate to express messages in this way, and where we don't want workers and people accessing facilities who are already under strain to face even more strain because of the bad behavior of somebody attempting to promote a message about whatever it is.
Member.
Thank you, Madam Chair. But again, the impetus for this legislation here and across the country has been specifically about people protesting the public health measures, vaccinations, masks as related to COVID-19. The minister indicates that we lack the specificity in this bill because there could be other protests, and I agree that we wouldn't want anybody interfering with access to hospitals or to schools. Has that happened outside of COVID-19 protests in the near past or at any time recently to indicate that that would be necessary?
Minister.
Thank you, Madam Chair. One of the realities, I think, of the situation we face here is that I don't think anyone anticipated that we would need legislation like this. I don't think people at the beginning of the pandemic, certainly I didn't think that we would reach a stage of the pandemic where we would need to protect hospitals and schools from people who were opposed to vaccines, blocking access to those facilities in order to get a message across. I don't know why we would wait for someone else to think, what a great idea. I've got a concern about my own personal issue. I think I'll go block an emergency room entrance as well. I think I'll go block a testing site, because that seemed to get a lot of attention for that issue. My message doesn't have anything to do with COVID, but I like that approach as a way to get attention. I don't know why we would wait for that kind of copycat approach, or why we would ask a police officer to determine what the message is first before acting about somebody interfering with access to the facility. So that's why we made the very explicit and deliberate policy decision that this is not about the content of what is on your placard when you're blocking an entrance to an emergency room or a testing site or a school, or intimidating a student or a teacher or someone who works in a school. This is about making sure that we're minimizing strain wherever possible on essential workers and protecting the right of access of British Columbians to these essential services.
Member.
Thank you, Madam Chair. This is another interesting point, is that the minister talks about healthcare centres and schools, and yet in the definitions in Clause 1, facility is defined as includes a site at which a service is provided. And so that doesn't actually specifically indicate, as other legislation in other provinces has, healthcare services or education sites. It simply says at which a service is provided. The BC Civil Liberties Association has noted a series of concerns with this legislation, specifically that it has the potential of being overly broad for the purpose of restricting protests not just near healthcare facilities and schools regarding COVID-19, which we are, I believe, as a House, all in agreement that that is an important step for this province to take, as have other provinces. We all are in agreement that there should be no interfering with healthcare facilities or schools. But the BC Civil Liberties Association has noted concern that this legislation potentially, and this is a quote, opens a sneaky door to morphing this into something similar to Alberta's Critical Infrastructure Defence Act, which restricts protests near pipelines, highways, mines, farms, and other industrial activities. So I'm curious as to why the minister is communicating quite clearly about healthcare centres and schools. Why isn't that defined specifically in the legislation?
Minister.
Thank you, Madam Chair. So a few points. The member notes correctly that facility has a broader definition in the definition section than section 3 sub 1. So I'll take the member to 3 sub 1, even though we're not there, but just for reference, clause 3 sub 1 defines a number of different facilities: COVID-19 testing sites, COVID-19 vaccination sites, hospitals, schools, and then E is prescribed facilities. So I'll take A through D first, which talks about testing sites, vaccination sites, hospitals, and schools. It would be easy to read this and think, okay, what government is talking about are physical facilities, and it might put into question whether or not a mobile testing site or a street nurse van, for example, would be protected by the legislation. And so that's why facility has a broader definition. It's a site at which a service is provided. So it could be a mobile testing site, it could be a street nurse van or something like that. We wanted to be inclusive of these different ways of delivering services during the pandemic and also reaching different groups. Because obviously public health has had to be innovative and try different ways of delivering services. Section 3, Clause 3, subsection 1, subsection E, has a class of facilities that are prescribed, which means that they could be established by regulation after this becomes law. And perhaps this is the area that the Civil Liberties Association was concerned about, because the others are clearly COVID-19 related sites or hospitals or schools. So what other, I mean, maybe the government is sneaking this in order to add a bunch of pipelines, or the member gave it as an example, where you couldn't protest. Section 6 sub 3, clause, 6 sub 3 of the Act sets out the factors that Cabinet must consider before adding a facility to the site. And those criteria include considering whether or not the facility is important to the health, education, safety, or well-being of members of the public, whether there's a need to protect access to those services, and also the strain that the people delivering services at that facility are under, and that these are services of public importance. Clearly, the legislation is not talking about pipelines. It's talking about services being delivered to the public at sites and the need for us to protect the rights of the public to access those services. It's important to raise these issues, but the Act clearly is talking about service delivery and protecting the rights there.
Member.
Thank you, Madam Chair. But the minister actually points to one of the issues here, and he said, as he indicated under Clause 6, that it would be up to the government and council to determine what these services are, to determine apparently what is a service of public importance, to determine things like what is the health, education, safety, and well-being of members of the public and the need to protect access to those services in the facility. I think when the BC Civil Liberties Association indicates that this looks like some overreach, it is the lack of really clear definition and the fact that we are no longer really specifically relating this to COVID-19 related protests or specifically relating it to healthcare provision or education. We are now talking about services, and that those services get to be defined at some future date in cabinet and not to be discussed here in this building by the Legislative Assembly. And so, you know, it's interesting to compare that to, for example, Quebec's bill, a one-page bill, very specific about the legislation being very specific, 50 meters from the grounds of the following places in order to demonstrate in any manner in connection with health measures ordered under Section 123 of the Public Health Act. And this bill says a place where COVID-19 testing or vaccination, similar to us, a facility maintained by a health or social services institution, a facility of the holder of child center or daycare, an education institution providing preschool, elementary, secondary, vocational, or college level education. And then we're done in Quebec. But what we have here in this bill is services. And I think that when the BC Civil Liberties Association indicates that this really does resemble something that's come out of Alberta, which restricts protests, and when I was asking earlier about, for example, would this include transportation infrastructure as a service? And maybe I'll put that to the minister right now. Does he consider that a protest unrelated to COVID-19 health measures impeding with transportation infrastructure would be something that would be considered by government and council, by council in the future as a service that impedes health, safety of the citizens?
Minister.
Thank you, Madam Chair. So a few points in response. So the act, the proposed act, sets out specific criteria that Cabinet must consider when determining whether to add a new facility. Now, extremely reluctant to set out a roadmap for people who have this perspective that disrupting essential services to the public is a way to get your message across. But I can maybe give an example of a facility that could, logically, I think, potentially be captured when vaccinations, for example, become available for kids who are under 5. They're not of school age. If licensed childcare facilities needed to be protected because they started to be targeted, we would expect, I think the member and all members would expect, that we would quickly move to protect access to those facilities. I am a little surprised to hear the Civil Liberties Association and/or the member advocating the Quebec model. We definitely recognize that Quebec put their legislation in place in a hurry to respond to a serious crisis in the province. So I don't mean this by way of critique, but we did make deliberate decisions that were different from Quebec, and the members should know about those just in terms of an overall approach and the constitutionality of this legislation in front of the House. Quebec, rather than 20 meters, is using a 50-meter barrier. They have what is a content-specific prohibition. It matters what you're saying, and it matters that what you're saying is opposed to the government messaging. So essentially, they have said it in their buffer zone, it is illegal to critique government public health policy. Specifically, you can critique other things in this buffer zone, but you can't critique government public health policy. And they put a blanket prohibition in place across the entire province around universities and colleges. And these are areas that when we looked at that, we felt that these were places where people have debates or are meant to have debates about public policy, including being critical of government public health policy if that's what they wish to do. And so ours is much more closely tailored. It's a 20-meter barrier. It is content neutral. It's about what you are doing. It's not about what you are saying. And it's not about whether you're critiquing the government or critiquing someone else, or it's about the fact that you're blocking access to a service of importance to the public. So I see some important differences between the bill that's in front of this House and the bill that's in front that was passed by the Quebec Legislative Assembly, which I point out out of a sense of, sort of mutual concern that's shared across the country about some of the activities that we've been seeing, and is not meant in any way to be a critique of the work of the Legislative Assembly in Quebec, only to say that we took a little bit more time and have a more carefully tailored approach as one that I felt and the government felt we could comfortably put in front of the members of the House to address this mischief of interference to public services.
The member from Abbotsford West.
Thanks, Madam Chair, and I should apologize for not having been here at the outset, but I will, in my defense, say that I had received an assurance from the Government House Leader that we would not commence until the briefing on the emergency briefing on the situation in Abbotsford and the province. And so I apologize, but had been provided with other assurances. But here we are. It's still on, so I've got here for the good part. I have ultimately some questions that touch a little bit on the theme that the leader of the third party has been developing with the attorney, and maybe in a slightly different way. And I expect I'll probably pursue them a little bit further in the bill when we talk about the regulatory power around prescriptions. And I will only say this, and the attorney may or may not wish to respond on this front. It's the dilemma that, and perhaps the confusion that exists with regard to a piece of legislation that has, I think, clearly been drafted in response to a particular situation and a particular set of circumstances, but as the attorney and the leader of the third party had said, in a certain way, is a little more open-ended in terms of the fact that it does not set as a prerequisite protest around a certain issue. I'm probably going to explore that a little more with respect to the regulatory power, and the leader of the third party and the attorney have touched on that a little bit. I would say also a part of the legislation that provides me and I think many people in the opposition with comfort is the sunset provision, but that further reinforces the notion that it is tied to a particular societal circumstance, that being around COVID, and yet other sections of the act, it's not large, it's not a lengthy act, suggest that there may be other applications. So I'll leave it at that. I thought with respect to Section 1, though, and the reference to access zone as a defined term, it might be appropriate to ask the attorney in a general way to explain practically how this works. And we'll take an example because it's not a fanciful one, a school. We have seen, and we can draw on the very examples that gave rise to the need for the legislation, the need for the legislation in the first place, where there has been a gathering. So, following the passage of this legislation, there will be an access zone created around that school. How does that work in terms of the entranceway and the perimeter of the school property? What, and I suppose when I say how does that work, how in the government's mind and the Attorney General's mind is it intended to work pursuant to the provisions of this law?
Minister.
Thank you. Let me just put on the record, apologize for the mix-up with the member. Obviously, we would and will give him all the time he needs to canvass the bill. It's exceptional circumstances in our province and in his constituency, and so the priority is to get him briefed about his constituents, and I hope he would be assured that we would make the time for him to be able to do his role as critic as well. With respect to schools, the relevant sections are Section 3, Sub 1, Sub D, and Section 3, Sub 4. 3 Sub 1, Sub D establishes access zones around the schools. As long as the school fits within the Act's definition of protected schools, and we can go into that if the member wishes. When you read it together with Section 3 Sub 2 Sub A, The protected schools access zone includes the parcel of land where the school is located, so playing fields, kind of boulevards around the front of the school, playgrounds, those kinds of things, along with a 20-meter buffer around the 20-meter buffer zone around that parcel. So for most schools, that would be the opposite side of the street from the school. Section 3 sub 4 clarifies that for schools, these buffer zones are in effect for the periods when you would expect students and staff to be at the facility from 7 a.m. to 6 p.m. on weekdays, other than holidays, and during extracurricular school activities, or when the buffer zone is in place. And the goal was to try to tailor it as tightly as possible to when students would be there. So that's there are also schools the member might note that are in multi-use facilities. So like an independent school that's inside a shopping mall, for example. Then the access zone is the entire parcel on which the multi-use facility is located, plus the 20-meter buffer. There are very few of these schools in the province, but there are some. And so we felt it important to give consideration to that.
Member.
Thanks, Honourable Chair, and that's helpful. So that's helpful, and that's fine. I think what I was more interested in, though, and we have an understanding, I think, of what a school is and how that's defined under the Act. But the model the government has and the attorney have chosen to pursue is to establish an access zone and then prohibit certain activities within the access zone. So to take the example, the entranceway to the school, and I'm not sure if it's the entrance to the school building itself or the entrance to the parking lot of the school. The attorney might be able to, so if it's 20 meters back from the entry to the parking lot of the school or to the building. But the Act doesn't say a person with a differing view on COVID-related matters or I suppose any other matter isn't permitted to be in the access zone, as I understand it. It says if they are in the access zone, they are precluded from, and this laid out in the next section, impeding access, physically interfering, or intimidating. So, do I have that correct? If I've got my sandwich board, and I'm otherwise entitled to be at a spot on a school ground, I'm not. This Act doesn't preclude me from being there, even if I'm in the access zone. It says if I'm in the access zone, there are some things I cannot do. Is that, have I got that right?
Minister.
Thank you, Madam Chair. The member is broadly correct with a nuance in terms of the sandwich board. Within the first of all, the question was about, is this the entrance to the parking lot? Is it the parking lot itself? The parking lot being on the parcel of land that the school sits on. The 20-meter buffer starts from the edge of the parcel of land where the school or hospital sits on, which would include the parking lot if the parking lot was on the property of the facility that was providing the service. And so you would go 20 meters, so it would be across the street from the parking lot. And so it doesn't really matter what's on the site, it's the parcel of land that the facility that provides the service sits on. The member is right in that you're still allowed to go into the access zone, but it's your conduct in that zone that this bill proposes to regulate. So it prohibits 3 different kinds of conduct within that access zone. One is conduct that impedes access or egress. So if you're preventing people from going in or coming out of the facility, that's something that is prohibited. That's 2 sub 1 sub A. 2 sub 1 sub B prohibits conduct within the zone that is a physical interference with or a disruption of the services. And it could be really any behavior, knocking over a tray of vaccines, engaging with school staff in an aggressive way that prevents them from delivering the services that they're intended to deliver, and so on. So this is meant to capture conduct that is a physical interference with the services at the site. That's 2 sub 1 sub B. Then 2 sub 1 sub C is the nuance that I would put about the person standing there just with their placard very peacefully within the zone, because it does matter what is written on the placard. So if what's written on the placard is something that reasonably would be believed to intimidate or attempt to intimidate people in terms of reasonably causing a person concern for their physical or mental safety, even though you're standing there peacefully, that the content of the placard could violate the prohibition in section 2 sub 1 sub C, and that requires an exercise of discretion by an attending police officer, and whether or not that content is intimidating or attempting to intimidate. So one of the reasons why this is set up in this way is, maybe you've got a group of parents, they want to show up and they say, well, we want better ventilation in the school. There hasn't been. We want to do a protest at the school. And they're holding signs that say better ventilation or whatever, and peacefully protesting. They would still be able to do that within the access zone.
Member.
Right. Okay, that's helpful as well. I don't want to preempt the discussion that I'm sure will take place at section 2. So I appreciate the attorney's remarks. We'll probably want to pursue the subjectivity of 2 sub 1 sub C a little bit further. My purpose in clause 1 was merely to try to get a sense, and he has helped by pointing out that it is, whether a school or a hospital or another facility, the property line from which the 20 meters is measured and outlined and confirmed, at least, that even within that access zone, it is not a prohibition of presence, it is a prohibition of certain types of conduct, and beyond that, outside of the 20-meter access zone, conduct that would otherwise be prohibited, that is prohibited under section 2, is presumably permitted, assuming it is otherwise lawful, permitted outside of that 20 meters. Is that correct?
Minister.
Yes, I think the member summarized it well.
Member.
Going back to the theme that the attorney and the leader of the third party were exploring, on the one hand, linkage between the legislation and the COVID pandemic circumstances, and on the other hand, the decision to de-link it for other purposes. The definition COVID-19 pandemic is tied to the COVID-19 related Measures Act, and I wanted that the attorney knows better than most. We are in the process in another room in this building or elsewhere in this building, extending or considering the extension of that the application of that legislation from its present end date of December 31, 2021 to December 31, 2022. This bill, and there is a specific section that deals with its absolute expiration on July 1st, 2023. I was curious about whether, what if any explanation there was for the delinking of those dates. If we're all if we're proceeding on the basis that the impetus for the legislation here was the COVID situation, but the attorney has introduced another piece of legislation that for the moment contemplates that it won't be required after December 31st, 2022, I was curious why this bill, the end date would be 6 months beyond that.
Minister.
Thank you, Madam Chair. So we're advised that there may continue to need to be administration of COVID vaccine boosters as well as COVID testing well past the date of the end of the public health emergency. So there will be sites at which we expect there's a distinct possibility of the need for the administration of vaccines as well as testing well after the state of emergency that the public health emergency around COVID has passed. So that's the reason for the disjuncture between the dates. The other legislation relating to measures around the public health emergency, which we do hope we will see the end of soon. The second piece of this is that date is the end, coincides with the end of a school year, and makes sense from a sort of administration and public understanding perspective, rather than having it end in the middle of a school year. And the third piece is, if it turns out that it's not necessary for whatever reason for us to have this in place, because we don't need to have testing sites in the same way, or we don't need to have vaccine sites in the same way sooner, then there is the authority under Section 6 to have an earlier sunset date than what's set out in the legislation.
Member.
Thanks, Honourable Chair. I followed the logic of virtually everything the attorney said about linking it to the end of a school year as it relates to those facilities. The one part of his answer that I suppose I should at least query briefly, the notion that testing and vaccination and medical treatment relating to COVID-19 may continue beyond the end of next year. My impression from some of the public health officials is that it may continue well into the future for a number of years. Is the rationale, in addition to the reasons that the date has been selected, recognizing that it could be ended earlier, is part of that rationale simply this, that the hope, and it's okay to have hope, the hope is that the likelihood or the tension that we have witnessed over the past number of months, that manifested itself in a very graphic way a few months ago, that tension will have passed by then.
Minister.
Thank the member for his timely reminder that hope is still necessary, and because I know a lot of people are feeling a lot of distress right now in the province, and I think the date that was chosen does reflect a hope of two things. One is that the system itself, the healthcare system, the education system, as more and more British Columbians are vaccinated and there are better treatments for COVID, that their systems, their work obligations, their interactions with patients, with students, and vice versa, will go back to normal. Or more normal anyway, that the strain on the system as a whole will be reduced. One of the reasons for this bill is to recognize that these essential public services are under such stress right now that we want to give extra protection so that a nurse who's only had a couple hours sleep, who's going back into work again, isn't confronted by someone yelling and screaming at that nurse and just saying, you know what, like, it's bad enough working in really challenging conditions. I don't need to be screamed at on the way into work. We want to protect and provide a buffer for those folks. So the hope is that the system has that resilience. The second is, of course, that COVID, like so many illnesses that can be stigmatized and cause fear and anxiety for people, that with treatment and vaccines becomes that the tension the member speaks about is significantly reduced around it, and we don't have a need for this. So there's really two different kinds of hope that we have here in terms of setting that particular date. And the third piece about the sunset date is that having a fixed date is a reassurance to people that we understand that this is an exceptional piece of legislation in exceptional times, and that there is a fixed end date that could only be extended by coming back to the legislature for the consent of representatives from across the province to extend it. But to shorten it, it could be done in a much faster, more efficient process on an urgent basis if necessary.
Member from Abbotsford West.
Thank you very much, Mr. Chair. I was going to ask this at some point in the conversation and the discussion about the bill, and I might as well ask it here, and I may ask it again with more specific reference to a few of the sections that follow. But I have heard and understand, I think, the explanation the attorney has given. Is he at all concerned that, in part, the message being sent by virtue of the construct of the Act, and I think there is broad agreement within the Assembly about what the intention is and what has given rise to the need for the Act, but by virtue of its how it's constructed, that if passed, certain activities are precluded from taking place within an access zone, and their intimidation, physical interference. And then when the legislation ends, there's I suppose one could conclude, someone might conclude, I guess that behavior is acceptable now. Whereas, and we'll come to another conversation, because I actually think it's going to be important for the attorney to place on the record the other tools that are available to address behavior that most people, reasonable people, would think is inappropriate, whether there is an access zone or not. But I wonder, does the Attorney General understand what I'm driving at here in terms of taking this unique set of circumstances, addressing it in a unique way, and say this cannot happen during the year and a half these access zones exist? To which people reply, okay, well, on July the 2nd of 2023, I guess that's okay.
Minister.
Thank you, Mr. Chair, and thank you to the member for the question. It's an important one. Even before this legislation passes and after it sunsets, there are a number of tools available to police trespass, mischief, breach of the peace, obtaining for a health authority or a school board, obtaining an injunction against somebody, engaging in certain activities in relation to a facility. So there are a number of tools that exist. This gives police one additional tool to respond in the moment, which includes the ability to arrest and to ticket an individual. Let's be frank about what we're talking about here. This is a breach of the social contract that we all operate under together in our province. That when someone needs to go to the hospital, we all pull over to the side of the road so the ambulance can go through. Is there anything can we hold the door for you? Like you're in distress. This is a small group of people that have decided that they wish to breach that social contract, and we hope that this is a short-lived kind of thing because it is so exceptional and so antisocial. And so I guess that's a third kind of hope the member was asking about. And then the other piece is that the systems that we're protecting with this legislation are so under strain right now. We want to send a message to the workers at those essential services. We support you. We know you're under strain. We know you're under stress. And we're putting all the pieces in place that we can to protect you. And to British Columbians, you have a right to access those services. And we're going to make sure that your right to access those services are protected. But really the fact that the systems are so strained, that there's so little resilience left at these really essential services, is what is animating a big piece of what's happening here. So it is possible, the member's right, that maybe this is something that appeals to a larger group of people. It appeals to people that believe in different issues as a way of getting a message out, as perverse as that idea is. And we might have to look at extending these provisions or altering them in some way to change them to be effective, to ensure that people are able to access their rights to access these services and to work in these really important jobs. Hopefully we don't need that. And so what we're trying to do is get this in place on an urgent basis to share the hope of everybody that this is a time-limited, tense situation for some people, and go from there.
Member.
Right, thanks, Honourable Chair. the attorney just said something, and I think it's important that he have an opportunity to confirm it on the record. When he talked about extending the provisions, I think I understood what he meant, but he might wish to confirm on the record. There is no mechanism under this legislation for that to occur. If future government decided that it wished to maintain beyond July 1st, 2022, the unique set of rules that govern an access zone, it would require introducing legislation to the Legislative Assembly to do so.
Attorney General.
Yes, the member is correct to extend past the date in the legislation of July 2023. What would be required is another bill in front of the legislature that would have to pass separately. There's not a mechanism in this bill to automatically extend these provisions or extend them by regulation or something like that.
Member.
I had one other general area that I wish to explore with the Attorney General. Then I understand the leader of the third party had some more questions relating to specific definitions, and it was a question that could arise in any number of sections, and I'll deal with it now, and it flows from something the attorney mentioned. We talked about some of those additional tools. The attorney and the government clearly have come to the conclusion that those existing tools were insufficient to deal with the circumstance that we were confronted by, that hospitals and schools were confronted by. And I suppose there is a requirement on the part of an opposition or official opposition to ask the attorney to offer to the committee and the assembly what it was about those existing tools that represented the limitation. We mentioned trespass. We mentioned some of the other mechanisms. Was it the immediacy of sanction? Was it the cumbersome nature of utilizing those tools? I mean, I won't try to speculate about what the answer is, but I think it's appropriate for the attorney and the government to say this legislation is here because the existing tools 1, 2, 3, 4, in our view, weren't sufficient to achieve the objective we were trying to achieve for the following reasons.
Attorney General.
Thank you, Mr. Chair. Thank you, Mr. Chair. I listed a number of different potential responses that exist now and will exist after the sunset period of this legislation. Staff have provided me with some challenges under the existing laws, and I think it's important to run through them, as the member says, just so the members are assured that we're not duplicating existing authorities. Certainly, some of the behavior would be seen to rise to a level of criminal liability. But keep in mind that the criminal law requires the proof of intent, the guilty mind, that the person intended to intimidate, intended to cause concern, intended to breach access, prevent access or egress from a facility. This bill does not require that. It is the activity, it is just in the legal term, the actus reus, it is just the activity of blocking the entrance, of causing someone to be intimidated, and in your behavior. So that is the difference between the criminal provisions and these provisions, which can make it easier for a police officer to be able to know whether the elements of the provincial offense are made out as opposed to a criminal offense like mischief. Breach of the peace is an arrest-only power for police. There's no criminal sanction that's attached to it, time in jail, a fine. This provision, this bill proposes significant fines up to $2,000 plus a $300 victim surcharge, up to 6 months in jail. And with respect to trespass provisions, they do have significant notice and procedural requirements. They require a health authority or a school board to potentially go to court. And it doesn't necessarily provide a practical option for responding to what are non-recurring instances. They may be at different facilities or at different school boards or different health authorities. Whereas this legislation provides a consistent framework, not just for police, but also for courts in terms of injunctions. So that's an example of a few of the differences between some of the existing provisions and why we feel like this is an effective response and will be a useful tool for law enforcement.
Member.
Thanks, Honourable Chair. When we get to sections 4 and 5 of the bill, I'll ask the attorney to comment upon in more detail the exercise of enforcement as it relates to a police officer and the requirement or the option of obtaining injunctions and to what extent this represents a preferred approach to the existing mechanisms, but we'll come to that in section 4 and 5. I think my last question for the moment on clause 1 is simply my reading of the act is that, and the definition, protected school does not include a public or private post-secondary institution, and if the attorney could confirm that.
Attorney General.
Thank you, Mr. Chair. Yes, that's correct, and that was obviously a deliberate decision. It is the feeling of desire of government to recognize, and this is a distinction from Quebec's approach, that post-secondary institutions are a place for debate and discussion, and that the sheer size of some of these facilities, that and the scope of the restriction would be overbroad for what we were trying to achieve here. With that said, within a large post-secondary institution like UBC, you might have a COVID testing site, a COVID vaccination site. Those sites would be protected, or a hospital. Those sites would be protected on campus within the boundary of that particular facility.
Leader of the third party.
Thank you, Mr. Chair. Just picking up on a few things in the question and answers between the other two members. That the breach of the social contract that the Attorney General referred to, that these protests, when they did happen, were, I would argue, widely recognized as a breach of the social contract. There was significant condemnation of the activities and the behaviors, and in fact, they dissipated relatively quickly. There were a few, and then there was one just recently on a Remembrance Day ceremony. Once again, seems to have been the response was widely recognized that this was a breach of the social contract. And the public responded appropriately to that breach and made it very clear to the people who were engaged in these behaviors, we don't accept this behavior. This is a breach. And then the Attorney General talks about the urgent basis for bringing in this legislation as a result of those early demonstrations which have dissipated. Thankfully, I'm grateful for that. People are not doing this. And the existing tools, the member for Abbotsford West pointed, and I think rightfully, to the way in which this legislation can be seen as a delinking from specifically COVID-19, and the Attorney General has indicated indeed these protests might not be specifically related to COVID-19. However, I would say that, again, that very public response to that breach of the social contract, I think would indicate to people this probably isn't a very effective way to get your message across, because you're not going to be seen as behaving in a pro-social way. This is anti-social behavior. It's again, no argument here that any kind of healthcare facility, medical facility, vaccination, testing facility related to COVID and school facility should be included in these, the protections that this legislation offers. But I come back to the definition of facility. And I still have questions around how facility is defined as includes a site at which a service is provided, and how broad and vague that is, and how the need for this legislation, which felt very significant when it was being contemplated and communicated about by government, and the conversation to the public was this is specifically about these COVID-related protests and about protecting these sites. To move to this broad definition in some ways is a breach of the expectations, I think, that were attached to this legislation. And when I'll pull up not just Quebec, but Nova Scotia very clearly identifies healthcare facility means a place where health services are being performed, delivered, or received, including a place designated as a healthcare facility by the regulations. And, you know, other provinces also moved urgently, more urgently than we actually did, but moved in a way that was very specific and limited the definition. So I'm interested in knowing whether the Attorney General would be open to making that definition more specific. We already have a definition for protected schools, protected hospitals, but would that facility, could we contemplate providing a definition to that contains it to COVID-related services, as he mentioned earlier?
Attorney General.
Thank you, Mr. Chair. So I think it's important maybe to go back to a couple things. First is the definition of the word facility is broad and deliberately so. It doesn't in itself create the authority or create an access zone. That's not what the word facility does. This definition assists a court or a law enforcement officer in understanding the thing it is that we're trying to create the protection around, because, for example, there were vaccines being given in buses at the Tsawwassen ferry terminal, and bus doesn't have a parcel of land, it doesn't have a building, but it is a vaccination site, and a facility is defined in the definition section as a place where the service is being provided. So in this case, it's the bus. It's a 20-meter zone around the bus, just to avoid the possibility of a very narrow reading that says, well, you know, that's a bus is not actually a facility. So that's what that does. In order to establish an access zone, the only way that it can be done is for the requirements in Clause 3, Sub 1 to be met. So access zones can only be established for, and the member has said she doesn't have an issue with, I believe, A through D, which is COVID testing sites, COVID vaccination sites, protected hospitals, and protected schools. So you got to be one of those four things. The fifth thing is the ability for government by regulation to prescribe a facility, to prescribe a site at which a service is being provided. But again, the word facility here doesn't define what Cabinet or Lieutenant Governor and Council's responsibility or considerations are. Those are contained in Section 6, Sub 3. And if you flip over to Section 6, Sub 3, access zones can only be created by Lieutenant Governor if they have regard to that there are services of subsection A, there are services of public importance being delivered, that the COVID-19 pandemic has put strain on the people who are providing those services there. So it's a site where people are stressed out and working extra hard because of the pressures of the COVID-19 pandemic. Is this a facility where that is true? Lieutenant Governor Council has to consider that and have regard to that. So the member asked about a pipeline. Is a physical pipeline, is that a place where people are delivering a service where they've been placed under stress by the COVID-19 pandemic? And B, that the importance of the services provided at this facility, that they're important to the health, the education, the safety or well-being of members of the public, and that we need to protect access to those services and the facility for those members of the public. Again, a pipeline is a tough fit into that. And there's judicial oversight over this, and the court would say, could Lieutenant Governor and Council, could Cabinet have had consideration of these factors in applying the access zone to this particular facility? So I do understand the member's concern about the definition of that word facility, but it's really important to understand that that is not what allows government to create the zone, nor is it the extent of the restrictions on Cabinet in terms of where the zones can be created. Those restrictions are contained in different sections, 3 sub 1 and 6 sub 3.
Leader of the third party.
Thank you, Mr. Chair, and I appreciate the explanation from the Attorney General. It's helpful. However, I still wonder if facility was defined more specifically as related to the COVID-19 pandemic, as happens in the later clause. But if the definition in Clause 1 was specific, as is in other legislation similar to this, which it specifically indicates that we are talking facilities that are related to COVID-19, with vaccinations, testing, any other healthcare provided to citizens, then there wouldn't be the potential for confusion that exists right now about what is meant by a facility in this act.
Attorney General.
Thank you. So I think I take the member's point for a hospital. You know, there are people in a hospital who are getting treatment for COVID. But then there's a lot of people just going to hospital because they got injured or they have some other kind of illness. So it's, I mean, even a hospital doesn't quite match the member's proposed restriction on facility that it's associated with. But certainly a school, I talked about a childcare facility once vaccines start rolling out for kids who aren't school age, which we all, well, certainly I hope for my own under 5-year-old happens. The unifying feature of these services is not that they're COVID-19 related services. There are some that are, testing sites and vaccination sites. The unifying theme of these is that these are facilities where we've seen these kinds of disruptive activities take place. And it doesn't seem to government that the people who are engaging in these activities to disrupt services at this place are considering whether or not the services that are provided at the site are COVID services. I think what their analysis appears to have been is, will this cause disruption? Will this draw attention to my cause? And so that is why facility doesn't say COVID-related services, and nor do even the prescribed A through D subsections under 3 sub 1 in terms of where access zones are created.
Leader of the third party.
I've been accused of being persistent before, so no risk of that not happening again. The 3 sub 1 is an excellent indication that already hospitals and schools are identified as protected. Testing sites, vaccination protected. The facility is, what can be done is to extend that so that, as the Attorney General has pointed out, maybe it's a bus, maybe it's a temporary location, but those facilities should be, according to what the intention of this act was stated to be publicly, should be related to COVID-19. We've already got the coverage of any hospital, any school, that's listed here, vaccination site, testing site. And so in that vein, I have a proposed amendment, and I'd be curious to see what the Attorney General thinks of it, but that clarifies the definition of facility. Copies for everybody.
Okay, we're going to just take a 5-minute recess so everyone can study the amendment and digest it. Attorney General.
Thank you to the member for the proposed amendment, and I asked staff to have a look at it, and I can share sort of immediate reactions. The challenge with amending the definition of facility in Section 1 is that the word facility is used throughout the Act and includes schools. And I know the member has said several times on the record, and I agree with her, that schools are an area that we want to protect. If we adopted this proposed amendment, it would have the inadvertent effect, I believe, of creating a conflict, because the definition of facility would say it's a site where healthcare related to COVID-19 pandemic is provided, but we're protecting schools where that's not necessarily the case. And so we would run into that conflict. So what I think I understand the member is trying to do is to restrict the ability of government in Section 3, Sub 1, Sub E, to prescribe different facilities. The government should only be allowed to prescribe something other than a COVID-19 testing site, vaccination site, hospital, or school if it's connected to delivering COVID-19 vaccinations, testing, or other services. Essentially, it would constrain the ability to add new sites by regulation to only those sites where COVID services are delivered. If the member wished to do that by amendment, the way to do that would be to make a different policy choice, obviously, than government made under Section 6, Sub 3. And these are the restrictions on Cabinet, the test for Lieutenant Governor and Council to have regard to, in subsection A, services of public importance. Essentially, what we did here was say, there are many services that government provides that are important to the public, not just COVID services, that could be interfered with by these kinds of protests. That's why schools are in the list. And so we don't think that it's a good idea to say, only if you're protesting a COVID-19 related service, then it could be added by regulation. To say that if you're interfering with services of public importance, and I guess I need only point to, as an example, although it wouldn't be captured by this because it's not a service and on, but I mean, there was the Remembrance Day protest. There was no COVID-19 related services being provided there. So it's not that the protests are particularly targeting those kinds of facilities. So the strain placed on services of public importance, the regulation authority requires Cabinet to say, okay, is this connected to a service of public importance? The member suggests that, I think my understanding of the amendment is the member suggests that instead, Lieutenant Governor and Council in 6 Sub 3 should only be able to add another facility if the service is related to the COVID-19 pandemic, including any other healthcare related to recommendations issued by public health authorities in her amendment. Even on that kind of amendment, it feels duplicative of the existing Section 3, Sub 1, A through D, or A through B, when we actually talk about COVID testing sites and COVID vaccination sites, COVID-related healthcare provisions, and then as well as hospitals. So I think we just disagree about the need for regulation making power to protect other types of services. And so this amendment will not achieve even the intent of what I understand the member's intent is. We just disagree on that public policy issue. I won't be supporting the amendment, and I encourage members of the committee not to support the amendment.
So I was remiss in pointing out that we are debating the amendment to Clause 1. Leader of the third party on the amendment to Clause 1.
Thank you, Mr. Chair, and I appreciate the minister's explanation and his staff's response to this. I guess, and it's back to delinking. The title of the bill itself is Access to Services COVID-19 Act, and I will take up the Attorney General and reintroduce an amendment under Clause 6 or Section 6, so that we can have this discussion debate when it comes to the making authorities that are proposed to be granted in this bill. But it still comes down to, is this a bill about access to services COVID-19? Or is it a bill about services writ large? And is this effectively delinking this legislation that was communicated about publicly to be specifically about these protests related to COVID-19? And I think we've navigated this a few times in a few different ways, but indeed, my understanding of what the Attorney General has explained is, indeed, it is delinked. It is not specifically about protests related to COVID-19. It can be protests related to any other things. It is about these specific sites, hospitals and schools, vaccination testing sites, but also other facilities that provide services that aren't being specifically defined. And I think that it's important for the public to understand the implications of that this bill isn't specifically related to what, again, we all recognized as really unfortunate and unacceptable behavior of blocking entrances to hospitals and schools, and what we absolutely do not want to see, which is any kind of intimidation of people getting testing or vaccines, seeking health care. But I think that was the expectation. It was certainly my expectation, and I think the public's expectation about this legislation was that it was related to those very particular scenes that we saw unfold. And I am concerned about the bill having quite a larger reach, in particular without the clear definition of facility and the kind of ability of the Lieutenant Governor and Council to determine, what is public health, and we can get to that when we're discussing that section. But I will let unless there's any other comments on the amendment, I'm going to obviously support my own amendment and take it from there. Thank you.
Attorney General.
Thank you, Mr. Chair. Just in response to the member's comments, she said that that I was suggesting that this was about protests generally, as opposed to specific COVID-related 19 protests. If I said that, I don't think I did, but if I did say that, that's not correct. This bill is about behaviors. There are specific behaviors that are listed in the bill. Blocking access to facilities, interfering with the service delivery inside the facility, and intimidating people. What it is neutral on is what is the motivation, political motivation, for you to do this. You're anti-government public health measures? Okay, you have some other boutique issue that you care about, that you think making sick people wait to get into an emergency room is an effective tactic. Okay, it doesn't matter. What matters for the police officer on the scene, what matters for the person trying to get into the hospital or the school or the student or the teacher is that they are being intimidated, blocked, or interfered with in those essential services. That is what this bill is about. And the title is important. The access to services is the title of this bill. It is about access to essential services. COVID-19 is in brackets because COVID-19 is a key animating principle behind why we need this bill. These services are under huge strain because of the pandemic, and it is about the right of British Columbians to access services during the COVID-19 pandemic, and it is set out there in the Regulation Making Power 6.3, sub A. The strain placed on services of public importance and on those who use and provide them by the COVID-19 pandemic. The last piece is that this particular proposed amendment is from as staff think that they recognize it as coming from Nova Scotia. Nova Scotia itself took BC's Access to Abortion Services Act, adopted it into their own Access to Abortion Services Act, and then adopted that into their Access to COVID Healthcare Act. And they did not, in their act, protect schools, which we have done in this, which the member says she supports. Her amendment would have the effect of either undermining or contradicting that support. I encourage her not to support her own amendment. I understand her intention. This is not achieved by this amendment.
Just a quick reminder that masks have to cover both your nose and your mouth to be considered sufficient. Okay, so any more debate on the amendment to clause 1? No? Okay, members, we're about to vote.
Shall the amendment pass?
Oh, shall the amendment pass? All those in favor?
Nay.
Those against?
Amendment is defeated
Okay, amendment is defeated.
on clause 1.
On clause 1. Shall clause 1 pass?
So ordered.
So ordered. On clause 2, the member from Abbotsford West.
Thanks, Honourable Chair. Just, it's a series of questions, and the section can be broken down into a couple of different areas. With respect to 2 sub 1, sub A, sub B, sub C, is that language drawn from any other statutory model, or was it sort of tailor-made for the legislation before us?
Attorney General.
Staff advised that this is language unique to this bill.
Member.
In our earlier conversation, Mr. Chair, the attorney referred to when I offered up an example, and we're now getting into the guts of prohibited activities within an access zone. So in the model that the legislation creates, the government creates an access zone, and the legislation determines what cannot take place within the access zone, impeding access or egress from a facility, physically interfering, disrupting the provisions of services. Those strike me as relatively easily understood. It's the third one that the attorney earlier described. I'm not sure he used the word subjective, but it does import a fairly subjective test. We were talking about the case of the person standing within the access zone with either holding a placard or with a sandwich board articulating a particular view or position, and the attorney pointed out that yes, that is there's a potential for that to occur, but it would depend on whether or not the message contained on the placard was deemed to intimidate or attempt to intimidate. Now, it is subjective. I think it's appropriate to ask the attorney what in his mind qualifies as a message that would intimidate or attempt to intimidate an individual. And he indicated in his earlier remarks that the key individual to draw that, to make that decision or apply that subjective standard, I think he referred to the peace officer. So probably we should deal with the question in two parts. Some insight from the attorney as to what kind of a message on the part of an otherwise passive protester would qualify as intimidation or an attempt to intimidate. Well, we'll start there.
Attorney General.
Thank you, Mr. Chair. So the section, we're talking about section 2 sub 1 sub C, which is the one of the listed behaviors that are prohibited in an access zone. And the section prohibits conduct that intimidates or attempts to intimidate as the first set of conduct that is intended to be captured. That decision to use intimidate or attempts to intimidate was a deliberate signal to law enforcement that what we're talking about here is at the more serious end of the spectrum of behavior, and to give law enforcement a benchmark around other kinds of conduct. Because after it intimidates or attempts to intimidate, there's also or conduct that could reasonably be expected to cause a person concern for their physical or mental safety. So either it's intimidating behavior, it's an attempt to be intimidating that doesn't succeed, but clearly was an attempt, or some other kind of behavior which on an objective test, as assessed by the enforcing officer, could reasonably be expected to cause a person concern for one of two things, either their physical safety or their mental safety. And the member asked about examples of perhaps what we're talking about here. Signs that have been seen at some of these demonstrations include nurses are committing genocide. It's our feeling that that could reasonably be expected to cause a person concern for their physical or mental safety. Or vaccinating your children is child abuse, that this would also potentially be captured by this definition as an example of some of the real-life messages being delivered at the entrances of these facilities to healthcare workers and parents.
Member.
Thanks, Honorable Chair. All right, again, that's helpful in terms of beginning to garner an appreciation for what the government, at least, where the government sees that line. I think the attorney has, again, confirmed that it won't be him or one of his colleagues that makes that determination. It'll be a peace officer, presumably a peace officer on the ground, who is obliged to make that that determination. I'm gonna, because having this discussion in the abstract is pretty difficult. So I'm gonna offer up an example, and I'm actually gonna take it out of the realm of COVID, because my purpose here is not to add to the tension that might exist publicly. So we have an individual, a couple of individuals who are advocates for, and I think this is a reasonably plausible example, because I've seen some time ago this in real life, who are advocates for the prohibition of smoking, and who for whatever reason choose, I'll say a hospital because that's where I saw it, to stand there passively with a placard that says "smoking kills." Now, I don't get too worked up about that because I'm not a smoker. But I suppose the argument could be made that from the perspective of a smoker, that's fairly intimidating and may cause them to be concerned about their ultimate physical health, if not safety. Is that, to the attorney's mind, is that an example of, and it's graphic language, it's pointed, we seek civility, we are not legally bound to it, but it is someone obviously articulating a deeply held view in a facility that treats people who many of whom chose to smoke and suffer the consequences. Is that person crossing the line in the attorney's mind with respect to conduct within the access zone?
Attorney General.
Thank you, Mr. Chair. It's important to note that the provision requires a reasonableness standard, or in other words, in sort of legal phraseology, an objective standard in relation to causing concern for an individual's physical or mental safety. So there are limits to this standard. It doesn't prohibit behavior in an access zone unless a reasonable person would have cause for concern. I don't believe that the example the member has caused. In fact, there's probably signs inside the hospital that say smoking kills. So I don't think that would cause a reasonable person concern. It's not, I can see that somebody walking in would be like, oh man, this is this is causing me this is making me mentally unsafe, this sign. Police officer, I would like for you to remove this person. It's not based on the individual perception of that person. It's based on the enforcing officer's perspective. Is this a reasonable threat to this person's mental health and wellness, or is this not reasonable? And so we do, on a whole bunch of things, expect enforcing officers to be able to make that determination on edge cases. Now, this also goes the other way, where there's a tough as nails nurse going into the hospital, seen everything, dealt with everything, just doing the work. Person's just screaming at that nurse on the way in, and the nurse is like, you know what, whatever, I've seen it before, doesn't bother me at all, officer, not a big deal for me. That could still be a subject of enforcement by an enforcing officer using this provision, even if that particular nurse is not affected by that conduct and says that they're not affected. If on an objective standard, the police officer or the enforcing officer says, you know what, this, I think, objectively could be seen as intimidating and threatening to people attempting to visit this facility. I'm going to use this ticketing authority. I'm going to use this arrest authority, if necessary, to stop that activity. I hope that assists the member.
Member.
Thanks. It does, in the sense that we begin to garner a better appreciation for where the attorney, at least, and the government for whom he speaks, sees the line. Maybe having just said that examples are better than the abstract, I'll now revert to a more abstract question. It strikes me, and I'm curious to know from the attorney whether he agrees or disagrees with this proposition, that there is relevance, obviously, to the terms that are used: intimidate, threaten. But there is a difference between feeling intimidated, feeling threatened, and feeling uncomfortable. If the attorney gets my, we are, all of us, I suppose, at certain points in our life, confronted by things or signs or words that make us uncomfortable. But that is one step removed. Most reasonable people would say that is different than feeling intimidated or threatened. Does the attorney agree with that proposition?
Attorney General.
Thank you, Mr. Chair. Yes, I would. There are two pieces of the construction of this section that we're discussing that realize that policy objective of focusing an enforcing officer to the more serious end of the spectrum. One is the objective standard that this would cause a reasonable person to have this apprehension about their own safety. The second is that the specific examples that are given before that broader test are intimidates or attempts to intimidate, to signal that we're talking about more serious conduct.
Member.
Thanks, Honourable Chair. I'm going to move to clause 2, sub 2, and ask the attorney in the context of an example. And I think I want to preface my remarks, and I won't presume to speak for the leader of the third party, but I think we feel an obligation to poke and prod and ask these questions. In my case, at least, I do so not seeking to encourage people to man the ramparts and test this. I mean, protest and disagreement is a obviously very important part of our society, but in asking these questions, my purpose is not to in any way suggest that people should be running to hospitals and schools to launch certain kinds of activity or to test the legislation. I'm hoping that we can, through our discussion here today, do that in a meaningful way. Here's the example. You do find yourself at a hospital. Well, let's not use a hospital. Let's use a school, because I can think of some reason. The attorney has already mentioned a reason why parents at a school might gather to protest something that is taking place within the school their children attend. You're present as part of a group. Your intention is noble. Your desire is to conduct yourself in a reasonable way, but some amongst you have a different view on things, and slide into, and you're in the access zone. This is taking place within the next year and a half. You're within the access zone because you're at the front entrance to your child's school, with no nefarious purpose except to draw attention to whatever the funding issue is that you may wish to draw attention to, or something a teacher has said, or whatever the many reasons are for a protest. And some in the group go further and engage in one of the prohibited activities or behaviors listed in this section. My understanding of subsection 2 is your presence as part of that group leaves you potentially exposed to being charged under these provisions because you are part of that group. And I don't say that to over dramatize it. I just want to be clear on whether I'm reading the subsection correctly.
Attorney General.
Thank you, Mr. Chair. There's an important word in this section which talks about willfully participating in the gathering of people, and then there's another important requirement that the gathering of people is engaged in any of the prohibited behaviors. So two pieces of this test have to be met. One is you're willfully there, you intend to be there. And the gathering of people is engaging in a prohibited behavior, blocking access or egress, intimidating people, interfering with delivery of services. If you find yourself in that situation in the access zone, whatever your message, whatever your protest is about, you need to get out of that access zone, because the member is, in his description, I difficulty finding a fault with how he described it, but I did want to add in that those key words and that those key requirements of the section are there, that you are there willfully, and that the group is engaging in a prohibited behavior within the access zone.
Member.
Thanks, Honourable Chair. That is particularly helpful, and I don't want to belabor it, but I will perhaps prevail upon the attorney to repeat one part, particularly one part of the answer he gave, because insofar as the activities that gave rise to this legislation, it is actually not a fanciful question. I think a lot of people, I don't know this, I wasn't there, but my sense is that some people with strongly held views did show up at a healthcare facility wishing to articulate a particular point of view, and that gathering morphed into something very different. And I think the attorney's point is that under and because of the provisions of Section 2, Sub 2, if a person were to find themselves in that position, they need to leave, because if they don't, they risk being captured or being associated for the purposes of enforcement with the prohibited activities. And if I'm correct in that, then I think it's a in the times we live, it's a pretty important message for the attorney to give via the committee.
Attorney General.
Thank you, Mr. Chair. The member has described the situation accurately. If you are participating in a demonstration around a facility that provides an essential service, and whether it's a school or a hospital or another prescribed site, and you see people who are intimidating the folks who are trying to deliver that service or blocking access to people who are trying to deliver that service, and you're within that access zone, which is 20 meters around the property edge of the site where that service is being delivered, then you need to get out of that access zone, because you are very much in jeopardy of a ticket or potentially arrest as well.
Member.
Down to sub 3, and I have neglected to thank the folks from the ministry who provided us with a briefing, and I hopefully alerted them and the ministerial assistant from the attorney's office that with respect to clause 2, sub 3, sub A and B, a couple of examples. So the sections, just to summarize, we now have sort of canvassed what are prohibited activities within the access zone, but those prohibitions don't apply if a person is doing something or saying something in the course of a person's work under sub 3, sub A. Well, we'll start there. Dunner said in the course of a person's work. So what's an example of that? What's an example of impeding access or egress, physical interference, intimidating? I think the example we came up with during our discussion was perhaps a principal who stood outside a school and told someone, "You're not coming in," because it's my job to determine who's coming into my school, and I say you're not coming in. And if there are other examples along those lines, and if I'm correct with that, then I am obliged to the attorney for pointing them out.
Attorney General.
Thank you, Mr. Chair. Thank you to the member for the question. And I think we have a better debate when during briefings he raises issues that he would like greater explanation on, so I appreciate him raising this during the briefing. Section 2, sub 3, sub A provides an exemption from the Act for things, as the member said, a person is doing in the course of their work within the access zone. So this is meant to capture, just as it says, things that you'd be doing as part of your job. Just because you do have a job at the facility doesn't exempt you from the provisions of the Act. It has to be part of your job. So, if you're on the job and you're intimidating someone within the access zone, it still applies if it's not part of your job. Examples of exempted behaviors, one can imagine a security guard at a hospital or a school that could, the member gave the example of a principal. There are separate provisions, I think, for educators, but that there are people who restrict access to facilities as part of their job, and so by definition, they're within the facility. It's it's blocking access to somebody, but this is actually part of their job to do that. So that is an example of an exemption. Another one, you've got a van full of medical supplies, trying to get it into the hospital, and you're not doing a great job of getting into the loading bay, and you're blocking access to the hospital. You would be exempted from the provisions of the Act, while a person using your vehicle as a protest to block access to the hospital would be engaged in a prohibited behavior. Really hard to tell the difference between the two, except for one is part of someone's job, the other one not. Section 2, sub 3, sub B gives exemptions for things done or said in an access zone for protected schools that are part of an educational program or extracurricular school activity. So, for example, you got a big sporting event at a school, and so there's a lot of students gathering, and they're in a way that impedes access to the doors of some of the doors of the school, makes it hard to get in. This would be an exempted activity. You might imagine that a teacher engaging in some sort of role play situation or real world debate over contentious issues or whatever, a workshop that could cause someone to feel intimidated or have just not be particularly well executed in that it incidentally made someone feel concerned about their personal safety. This is an exemption that would apply because it's part of the programming at the school. Thank you.
Member.
Thanks, Honorable Chair, to the attorney. That takes us down to Clause 2, Sub 4, and I am going to ask the attorney to offer up to the committee the rationale for the inclusion of Sub 4. I'm going to ask it in this way, which is hopefully first of all understandable, and secondly will prompt the attorney to offer up the government's rationale. So we have, I think, agreed that this is a somewhat extraordinary measure, this bill, Bill 20, to address an extraordinary circumstance. And have said, and the attorney has said on behalf of the government, that preserving access at this difficult time for people to the services offered at a hospital and a school is important and worthy, and requires the existence of this additional tool to protect that access. Good. I've got that. And we have just canvassed, and I think the attorney's made a case for why the exemptions under sub 3 make sense in contemplation of the kinds of things that can happen at particularly at schools, but also at a hospital facility. So then we come to the labor relations exemption, and I'm going to put this proposition, and the attorney may or may not agree with it, but in the context of a labor dispute, and they happen, and they're an accepted part of the labor relations process. But at a practical level, they frequently, and for good reason, the withdrawal of service has implications for the employer, but also for the employees who are denied income. They are fraught with emotion, and in certain circumstances, where employers in an essential service context, which is pretty plausible when we are talking about healthcare and education facilities, may bring in people to replace those that have withdrawn their services. The Act says the Act is very specific about prohibiting intimidation, and yet in those circumstances, in the ordinary course of labor relations, I don't think it's an exaggeration to say that part of the exercise of the picket line is sometimes very purposeful, and that is to intimidate people not to cross it. And so it strikes me that what the government is saying by including this provision is that notwithstanding the extraordinary circumstances that we say exist and may exist for up to the next year and a half, to the extent that I have fairly or accurately described an element of intimidation that I hope people will accept is a reality in that setting, the government is saying that's okay. And I'm curious, now the attorney may take issue with my example or how I've characterized it, but I am curious to know the rationale for saying in that particular circumstance for the next, up to the next year and a half, we're okay with allowing that kind of intimidation to the extent that that is a feature of a labor dispute and a picket line.
Attorney General.
Thank you, Mr. Chair. So there is, I understand how the member got to where he ended up, but there is a whole separate regime that regulates activities on picket lines, where they take place, when they take place, how they take place, administered by experts in labor relations, and a separate piece of legislation. So that's the reason for carving it out. It's not like, oh, you're allowed to go and intimidate people if your purpose is this. It's that there is a separate system that regulates this, and that there are obviously, as the member rightly noted, important nuances about the collective bargaining process and strikes compared to a protest. So the way that picket lines work is, functionally speaking, there aren't really such things as spontaneous picket lines. In order to have a picket line within the Labor Relations Code, in order for the activity to be lawful, and it's important to note that unlawful pickets are not permitted at the exemption that is provided here in the provision. But if it's a lawful one, the board, the employer, and the union already know it's lawful because the employer or union has to have fulfilled the necessary preconditions, and the board will have provided a letter confirming the precise date and locations at which the strike and lockout activity and picketing can occur. So it's being overseen by the Labor Relations Board and pursuant to the Labor Relations Code. And so it is quite distinct and different and quite nuanced, and we felt it better policy to leave it to the experts in labor relations, given that there's a full regime to deal with those kinds of issues, rather than to put it into this bill in relation to protests and activities that are not captured by the Labor Relations Code.
Member.
Thanks, Honourable Chair. It is not my intention to belabor, pardon the pun, this point, but I don't think it is an exaggeration to say that we have all been confronted in the heat of a labor dispute, and that the Labor Board itself accommodates and allows for behavior, and yes, there is a body of law that regulates this, but it contemplates, for example, the placard that says someone reporting to work during a labor dispute is pretty unflattering. And our laws accommodate that. I don't think it's an exaggeration to say that in the context of that labor law scenario, there is an understanding that there will be an element of intimidation. There will be a purposeful desire to stop someone from crossing a picket line in certain circumstances. Not always, but in certain circumstances. So whilst I understand the attorney's point that says, well, there is this body of law over here that that exists and that we can draw from. That body of law, I would suggest, over time has evolved and has deemed acceptable a certain measure of intimidation exercised in a certain way. And I guess I'm just, it strikes me that by its inclusion here, the government is saying for the next year and a half or up to the next year and a half, there is a unique set of circumstances that should prevail that will limit rights that otherwise exist. But we have determined that that is not the case with respect to, as the section says, a strike, lockout, or picketing. And I suppose I'm just probably seeking an acknowledgement from the attorney that in the event that a strike, lockout, or picket takes place during the next year and a half or up to the next year and a half, there may well be an element of intimidation or attempted intimidation that takes place within an access zone, and that is a purposeful decision on the part of the government to allow that to occur.
Attorney General.
Thank you, Mr. Chair. I think a couple of things. First of all, this approach to recognizing that there's an entirely different structure and system of rules and determination of conduct for a certain kind of very specific protest, which is a strike and a job action, is the recognition that that is handled by a separate body of law, a separate adjudicative body, and so on, is not unique to British Columbia. Exemptions like this are in the legislation put forward in Quebec, Nova Scotia, Saskatchewan, Ontario, and Manitoba. Now, notably, I didn't include Alberta in that list. Alberta did not include an exemption. They took a different policy approach. This is not, workplace actions are not, and have not, to the best of my knowledge, created the issues that this bill is attempting to address. If they did, the member could reasonably expect to see us back here if we felt that the Labor Relations Board wasn't addressing the issue, that there were problems with strikes interfering with access to essential services like healthcare for British Columbians. I think it, just like anything is possible, theoretically possible, extremely unlikely is how I would categorize it. But if it did, the general policy approach of this bill is to suggest, and I would suggest to the member, that the decision by government would be that the amendments and the approach would be better taken through the Labor Relations Code rather than through standalone legislation.
Members, shall Clause 2 pass? Aye. So ordered. Member on Clause 3.
Thank you, Honourable Chair. I thought the best place perhaps to begin, and we've touched on this conversation, the attorney and the leader of the third party, when we were dealing with Clause 1, But the attorney has explained, and it's self-evident, the appearance of sub A through D in terms of the facilities, and they are defined terms. So the interest that I think we will have relates to sub E and the power that the attorney and the government have preserved to themselves to add facilities beyond those enumerated. And I thought the best place to start was just to ask the attorney if he can to offer up some kind of a construct for or an indication what the test would be, or what would trigger over the next up to year and a half the government exercising the powers under sub E and adding a prescribed facility.
Attorney General.
Thank you, Mr. Chair. So what the member and what I expect the public, having been made aware of this authority, would expect, and what government's intention is that if there were a demonstration or a protest in which people engaged in the behaviors that are described in this bill, the intimidation, physical blocking, interference with delivery of services of public importance, and it was not at a facility or a site that was captured by subsections A through D. So in other words, not a COVID testing site, not a vaccination site, not a school, not a hospital. And it seemed that, and so that this activity took place, it was at a site that wasn't captured, then the member could expect that government, that specifically cabinet, lieutenant governor, and council, would have regard to a couple of things. One is, and these are all captured in section 6 sub 3, the strain that activity placed on services of public importance, that protest had an impact on the delivery of the service and on the people who provide that service, that they were already under strain because of COVID. And so the people who were affected were already being strained by the COVID-19 pandemic, and that the services at the site were important to the health, education, safety, and well-being of members of the public, and that there's a need to protect those services and the people providing the services of the facility. So you see the protest, it meets the requirements in 6 sub 3 in terms of the regulation making authority. The member could expect the government would be adding either that specific facility, like it's a one-off kind of site, or facilities of a certain category, for example, childcare facilities that meet certain requirements in whatever the regulation would be set, that government would be adding either that site or that category of sites through regulation.
Member.
Thanks, Honourable Chair. So to put some meat on the bones then and get a sense of what that, how that actually plays out, I'm going to again try to present a scenario that I hope is not fanciful. I hope it doesn't happen, but I hope it's qualifies as a realistic example. The folks with strongly held views decide that a way to draw attention to those views, let's assume they relate in some way to the COVID pandemic, but that's not an essential element of the bill, but let's assume for the purpose of the example that they do, and that a way to draw attention and advance their their opinions is to impede access to certain ferry docking facilities, a service. What I think the attorney has said is that in determining whether or not to add a particular or group of ferry terminal facilities to the list of prescribed facilities under sub E, the government would be guided under this legislation by 6 sub 3. I won't go reread them. We've canvassed that. I'm going to suggest that a fairly compelling case could be made that in those circumstances the test under 6 sub 3 would be met or could be met. I'm not asking the attorney to provide a definitive answer about something that hasn't happened and hopefully won't happen, but I think it is fair to say or to ask him if he believes it would be an option under this legislation for the government to add a ferry terminal under 3 sub E as a prescribed facility.
Attorney General.
Thank you, Mr. Chair. I'll try to be as specific as possible in the response and try to achieve our shared goal of, one, my not being definitive about this, because it is very much a case-dependent kind of thing, but also to use the example the member provided to draw out some of the considerations the government would go through in terms of whether or not deciding to add, in this example, a ferry terminal to the list. So in terms of the considerations government would give is, have ferry services and ferry service providers been under particular strain as a result of the COVID-19 pandemic? And so that would be a key consideration, and it would require engagement with the service provider and determination on that basis of whether that was indeed the case. And one consideration that Lieutenant Governor and Council would likely consider, although not listed here specifically in A and B, is whether there are other provincial tools, in other words, tools that don't require the mens rea requirement of the criminal law, for example, that police could use for a ticketing response. And in this instance, there is another tool that would be available to an enforcing officer using the Highway Act. Blockage of a road or blockage of access to a ferry terminal would be an offense provincially under the Highway Act. And so that may be a consideration mitigating against government adding a provision to this bill when there are other tools that the police could potentially use effectively in the first instance, as opposed to waiting for the even a regulation takes some time to add by government, and police could respond immediately using existing tools. So those are some of the considerations without, as I say, providing a definitive answer that the government would go through in the example of, say, a ferry terminal.
Member.
Thanks, Honourable Chair. Is the dilemma the government faces, again, using my example, which is only an example, in relying or determining whether those other tools are available, that they largely exist outside of the control of the government? The attorney would be the first to indicate it's not for him to direct a a peace officer to issue a ticket or not, nor his colleague, the Solicitor General. Whereas in this instance, through the signing of a one-line OIC, the government would be signaling in pretty explicit terms what its view of the behavior is, so that notwithstanding what the attorney has said about the existence of other tools, this represents one, at least the adding of the prescribed facility that falls within the exclusive jurisdictional authority of the government. Now, what follows from that reverts back to enforcement officers. That is certainly the case, but it would represent a pretty strong signal on the part of the government as to how it views the behavior. Is that a fair comment on my part?
Attorney General.
Thank you, Mr. Chair. Before I answer the member's question, one correction, Manitoba has not passed. I said that Manitoba Manitoba had a provision exempting organized labor job action. In fact, Manitoba has not passed a bill, and staff advised me that they don't believe that the draft bill had that provision in it in any event. So I was wrong on not one, but in fact 2 counts in listing Manitoba in that list. In terms of the member's specific question, what I understand the member to be asking is, isn't this about as close as government can get to directing the police that they need to protect a certain facility by using this law in relation to activities that are happening there, and reserving that power to Governor and Council, Lieutenant Governor and Council is reserving that authority to Cabinet. You're rightly acknowledging that the ultimate decision is made by a law enforcement officer, but doesn't that bring a lot of pressure on that officer to actually make that enforcement decision if you've specifically added this to the list? I would say a couple of things. The short answer is, I think yes. I think the idea here is that by passing this law, that the Parliament is saying, okay, we think that public services of importance need to be accessed, and that there are a number of services that are under strain because of COVID, and we need to have that 20-meter barrier access zone around them to ensure that people are able to access those services. And we do hope and expect that police will use this tool that we gave to them to be able to ensure that those services are accessed by British Columbians. And if a site is added to the list, it reflects the intent of certainly of Executive Council, Lieutenant Governor Council, to communicate to the police, we hope that you preserve access to this facility for the public. The member is right to note that the ultimate enforcement decision is made by police, and this place has passed a number of laws that police exercise that discretion around. There are a number of regulations that police exercise that discretion around. And I think that the significant pressure on police would really be public pressure, because these have been very high profile, as we discussed with the leader of the third party, high profile instances of breach of the social contract that have met with public revulsion. And that is likely what would animate the police action rather than government adding a regulation, in my opinion. But it would certainly be a communication of Lieutenant Governor and Council's intent and hope that police would use that tool if access to those services were being blocked.
No, Abbotsford West.
Thanks, and welcome, Honourable Chair. I'm going to alert the leader of the third party, and I'm going to ask one or two questions. And I expect, I don't know this, but I expect it's going to be a point of entree into an area that she has indicated an interest in. And it relates to what we were talking about. And I'm going to shift to another example, because the attorney has already heard an element of concern and curiosity about, because of how the Act has been structured, and the attorney has explained the rationale for that and the desire to have the option to add facilities as defined here in circumstances where that is deemed appropriate and the test is met under the Act and under 6 sub 3. So here is another example, and again, not a fanciful one, a publicly owned transmission corridor where there is protest, where the situation has escalated to a point where people involved with that, the construction of that public transmission corridor, the pipeline, are now feeling threatened and very much concerned. If I go to the test that the attorney has properly referred us to under 6 sub 3, which asks the Governor General and Council to consider the strain placed on services of public importance, and if whatever one's view might be, if the Crown is involved in the construction of something, it is presumably deemed publicly important. And to those who provide them by the COVID pandemic, and presumably anyone involved in that location is, in a location like that, is impacted. And I then go to the secondary test, the importance of the services provided to the health, education, safety, and well-being of members of the public. I mean, I can make an argument relatively easily that those tests are met, and there are people in this room who are probably would be happy to come to that conclusion, and others that would be maybe a little more reluctant. But I think what the attorney is going to hear from in more detail from the leader of the third party or her colleague is a series of questions around the potential for expanded use. I think the first example I gave, I didn't detect a lot of hesitation on the part of the attorney to contemplate that as a possibility. He may not view this in the same, or he may say, for the following reasons, I could never foresee this executive council, and I would be curious to hear that as well, and why. I think my point is, as with every law we pass in this place, as hard as it is to believe when you're sitting in the chair one occupies now, it may not be you, it may be someone else or another government, not likely in the next year and a half, mind you, but it may be someone with a significantly different outlook on how to use the tool. So a different example, and interested to hear from the attorney why in that case, if his view is, as he said earlier, it's not applicable, how he can say that with such certainty, because I could make a pretty compelling argument that the test under section 6 sub 3 is met.
Attorney General.
Thank you, Madam Chair. So Section 6 Sub 3 talks about services of public importance that are provided at the facility to members of the public. So I'm struggling to, the member, as we all do as lawyers, believes that he's constructed a very good argument that a construction site of whatever facility the member is talking about, a very specific site that's subject to an injunction, but really any construction site of either public or private nature, a SkyTrain, infrastructure that's either public or private, provides a service to the public. So the wording of the text describes the public accessing that site in order to obtain the service and to protect their right of access to that facility in order to access the service. Members of the public are not invited onto construction sites. They do not need to access construction sites in order to access public services. And so I think that there is a fairly significant distinction between the scenario that the member presents of a construction of a significant piece of public or private infrastructure and a facility where the public needs to have access in order to obtain a service there.
Member.
Thanks, Honorable Chair. My last submission on this, and then I think my colleague from the third party, I understand the distinction. So I understand the distinction that the attorney has made. I'm not sure I agree with him that the language is as clear as he would say. I think his indicating what the intention is probably helpful, but I'm not sure that the language is as clear. And again, hopefully this won't happen, but the government may be confronted in the future, both by those who fear an application of these provisions to address certain activities, protest activities, and those who call for it. So while I understand the distinction that the attorney has made in pointing out the intention around facilities to which the public is regularly attending and seeking access, I think another interpretation is that a construction site that will allow the public at some point in the future to have access would qualify as well, and maybe the less controversial example would have been a SkyTrain construction site that the public isn't yet accessing, but is certainly likely looking forward to accessing. In any event, I have, I think, articulated one area of concern around the use of the tool. The attorney has provided some insight into how he views the tool, believes the tool would be used in the future, and I think my colleague from the third party may wish to pursue some questioning on Section 3, Clause 3.
Saanich North and the Islands.
Yeah, thank you. And I just wanted to, could the attorney please clarify, was it Clause 6 Sub 3 that you just referred to, was it? So is it true that it's just the regulations that the government makes that can be changed, or that can be changed by the Lieutenant Governor and Council, not this section? Is that correct?
Attorney General.
Thank you, Madam Chair. So this section 6 Sub 3, and specifically I was referring to subsection B, where I believe my interpretation is, and the member for Abbotsford West and I disagree. My interpretation of subsection B is about protecting the access to the site for members of the public to be able to access a specific service. That is part of this legislation. So once this bill passes, it is part of the law of the province, can't be altered except through a vote, through an amendment bill that would have to come separately in front of the House. But it is an enabling section, 6 sub 3, in the sense that it's not really enabling itself, but it restricts the ability of government to just add any facility onto this list through regulation. It says that you can only add a facility if you have regard to these specific factors. And it refers to an enabling power in section 3 sub 1 sub E. So that's where you can have the prescribed facility, and then you can only prescribe a facility if you follow the rules that are in the law, which says, you have to have regard to section 6 sub 3 sub A and B. And so those can't be altered by regulation. Those are part of the law. What could be altered by regulation is if government added childcare facilities by regulation as a prescribed facility, and then realized that, there was some interpretation issue where we needed to be really specific about private childcare facilities as well as public childcare facilities, and so that could be altered by regulation. But what couldn't be changed by regulation is 6 sub 3 sub B. If it passes the legislature, it's part of the law, and an amending bill would be required.
Just a reminder to address through the chair, please. Member.
Chair. Attempting to wipe clean the work that I was doing in the other house and pick this work up. So I appreciate that. Thank you. The BC Civil Liberties Association has raised a concern with respect to Clause 3.1e and 3.4b around prescribed facilities. And in quotes, in the case of any other facility at all times. These two clauses are concerning the bubble zones, and they could be, the fear is that they could be expanded to include critical infrastructure. I think the Minister, the Attorney General is talking about now. What other facilities might the Minister anticipate including under 3.1e? I think you just mentioned one, but can you maybe expand on that a little, what might be considered under this?
Attorney General.
Thank you, Madam Chair. So there's a couple of considerations here in responding to the member. The first is extremely reluctant to provide a list of sort of a roadmap of potential vulnerable facilities that people might target that we have been considering around the need for protections. What is easier and I think maybe more helpful is to just work through section 6 sub 3 a little bit in terms of the restraints that it proposes to place on government's authority to add additional sites, Lieutenant Governor and Council's ability to add additional sites. So in 6 sub 3 subsection A, the first regard is in terms of the services that are delivered at this site, and we had a discussion with the member for Abbotsford West about a ferry terminal, for example. In terms of the strain of the folks who are working at that site that the pandemic has placed on them, is this a significant impact that COVID has had on the delivery of the services and the people who deliver it? Are they under stress? Are they facing extra burdens? Is there a need for extra protections for the people who are providing those services? And contained within 3 sub A is that the service has to be one of public importance. This has to be one that the public relies on and is important to the public as a whole, or a cohort of the public that is dependent on those services. Then, so as long as you meet that first requirement, okay, these are services that have been strained by the pandemic. Everyone there is really stressed out by the restrictions and so on. The last thing they need is someone screaming in their face that they're committing genocide or whatever it is. One of the signs the member may have not caught the earlier portion of the debate is that nurses are committing genocide was one of the signs at one of these protests. And so the last thing that a group of people needs is to face those kinds of additional strains and stresses as they try to get in the door to go to work. So that's the first sort of restriction around or guidance to government in what they need to have regard to in adding a facility. And then the second subsection really talks about the specific services. Do these services that are provided at this facility that government wants to add to the list, are they important to health? Are they important to education? Are they important to safety? Are they important to the well-being of members of the public? And I think we could all probably think of a significant number of services, and they're not just publicly delivered services, but they could be privately delivered services that might check off one of these boxes. And is there a need to protect access to those services in the facility for the public? That something has happened, there's a reason to believe that access to these services of public importance has been compromised or will be compromised by people engaging in the kinds of activities that the Act prohibits. And so that hopefully gives the member some idea about the category of services, service delivery, as well as the workers and the people accessing those services that we're seeking to protect by this Act and to anticipate that we may need to protect through regulation.
Member.
Yeah, thank you for the response. And through you, Madam Chair, to the attorney, the minister, who defines and how is public importance defined?
Attorney General.
Thank you, Madam Chair. This is not, as the member, I assume, is noting, this is not a defined term in the Act, but that doesn't mean there aren't important signals to a court, for example, providing oversight of government's use of this authority. The principles of statutory interpretation are that the court would look at what are the other kinds of services that are protected? Schools, hospitals, COVID testing and vaccination sites. What is the context of this regulation making power? What evidence is there that the government is leading? What information is in front of the court that this is, in fact, a service of public importance? It's important to note that at the end of the day, if someone looks at, government has added some kind of a facility to the regulation, and they disagree that the services that are provided there are of public importance, they can go to court, and then a court would interpret this provision about whether this is a service in line with those other kinds of services in the context of the Act or not. And so there's oversight, but there's not a specific definition of public importance beyond the dictionary definition and the statutory interpretation context that a court would draw from.
Member.
Thank you, Madam Chair. I think that this highlights a challenge that has been identified with the way that this bill has been drafted, just simply because of the levels of interpretation that are required on a variety of fronts here. Interpretation from the Attorney General and the Lieutenant Governor and Council, determination or interpretation from the courts makes this challenging because it leaves a whole bunch of it leaves a whole pile of questions, I think. So through you, Madam Chair, to the Attorney General, isn't it true that the minister's colleagues over the last 20-something months that we've been faced with COVID have repeatedly and on the record talked about the strain that COVID-19, and I'm using the strain, maybe it's not a direct quote, but the impact, alluding to strain, that COVID-19 has had on all services in this province. It often is used as basically I think the term would be qualifier, that we're delivering the service, but recognize that COVID-19 has had a tremendous impact. Again, I'm paraphrasing, but isn't it a true statement to say that I think that most, if not all, ministers have noted the impact and the strain that COVID-19 has caused on the service delivery in the province?
Attorney General.
Thank you, Madam Chair. So a couple of pieces. First of all, I think it's important to look at the section 6 sub 3 sub A, and it is indeed the strain placed on services. And I think a lot of us in this room would agree that there has been significant strain on many different services. And there are also degrees of strain that have been placed by COVID-19 on services. Some profoundly affected, some less so, but still affected. But then there's a modifier, which is that these services have to be of public importance. And so there is a guidepost there about this isn't just any service that's available to somebody. This has to be something of public importance. Pardon me. So I take the member's point. The pandemic has had far-reaching effects. The direction here to Lieutenant Governor and Council is to consider the amount of strain. And to take the member's point, maybe we're talking about really a spectrum here from business as usual to just extremely long shifts, long hours, huge demands, and everything in between. And so that is part of the weighing exercise that's called for here. But what's not part of the weighing exercise is that it needs to be a service of public importance. The second is the member says, well, there's all this sort of, what does it mean, public importance, and how is it going to be interpreted? And that this means that there's not specificity. There is a public policy decision here in the regulation making power, which is that none of us, I don't think, I didn't conduct a poll, but I was surprised, unpleasantly, to learn of the tactics engaged in by some individuals to block access to emergency rooms, to spit at essential service providers, to intimidate kids and principals inside schools as part of a political effort to raise public awareness of their concerns. And so the public policy decision that's reflected in this section is, this behavior and these specific important public services are just, the concern is that these individuals are willing to breach any number of sort of public commitments we make to each other. If you're on your way to the hospital, I'm not going to block you from going to the hospital. This is something as human beings that we have a sort of shared understanding about. So what other sites, what other facilities will these folks engage in? So there were two possibilities. One was we brainstorm a list of as many important public services as possible, put them all in the act, and essentially create a roadmap of all of these sensitive, important public services that, hey, you might want to have a go at if you're so reckless as to block emergency room access, which is the approach that has been taken by some other jurisdictions. And I think a legitimate public policy decision, I'm not critical of it, just not one that we took. Instead, we took the facilities where we know these activities have taken place and said, if we see those kinds of activities at other places, we have reason to be concerned that that's going to happen, that we could add sites on at a later date. And so in making that decision, there are two ways to do it. One is to say government can add other sites. period. And could be anything. Or to say government can add other sites, and here are some restrictions on the ability to do that because these are not insignificant authorities. So $2,300 fine when you include the victim surcharge, up to 6 months in jail. These are significant consequences. And so we want to make sure that there's some guideposts to government and Lieutenant Governor and Council in setting regulations. What should they be? Important public, important services, services of public importance, pardon me, and that the facilities under strain as a result of COVID, and that the services are important to a number of categories of protected service. So the goal here was to not be exclusive, not to make a roadmap, and also to provide some assurance to the House that it's not an unrestricted authority. A member might agree or disagree that we hit the target here, but I thought it may be useful to describe what the thinking was and why there's a short list of specific facilities as opposed to a long list of vulnerable sites.
Member.
Thank you. Thank you, Madam Chair, through you to the attorney, and I appreciate the explanation. And I hope the attorney understands that these questions here are not in any way to suggest that the behavior that we saw this summer and is something that I support in blocking people from getting access to the healthcare and education services that they need, but simply that what I'm trying to test, and I think what is being tested here, is kind of the scale of the powers that we are, when this bill passes, granting to the Lieutenant Governor and Council, and that's what I'm hoping to get here. It's that I think we want those services to be delivered and secure, and that's the point of this here. As the Attorney General was reading through Clause 6.3b, it was noted the importance of the service at the facility to the health, education, safety or well-being of members of the public were kind of separated out from the last piece, which is, and the need to protect the access to those services. In the reading of this sentence, there is no comma after public, is the factors that are being determined limited to the first three, and in addition to one of those three, the need to protect access to the public, or is the need to protect access to those services in the facility also a factor that could be determined, could be used to determine that a facility is a prescribed facility?
Attorney General.
Thank you, Honorable Chair. Just talking about the Oxford comma. It's good times here. In case anyone was wondering. Probably not. The chair's favorite comma, I'll put that on the record. It's gonna be anyway. Okay, so Section 6, Sub 3, Sub B. I'm going to run through it as if it were its own sort of section and series of subsections. So there are 4 categories of service that are contemplated here. One is that the services are important to health. That's the first. One is that the services are important to education. That's the second. One is that the services are important to safety. That's the third. One is that the services are important to the well-being of members of the public. So in order to add a site under this section, the services provided at the facility need to be important to one of those four categories. And then the word "and" shows up. So it's not enough that the services are important to one of those four categories. There's a second part of the test, which is that there is also the need to protect access to two things. One is access to the services, and the other is access to the facility. And so when you have a situation where the services are important to any one of those four categories, health, education, safety, or well-being of members of the public, and you have a need to protect access to those services and the facility, that is the situation that is contemplated by the regulation making power here.
Member.
Thank you. Appreciate the explanation. Through you, Honorable Chair, to the attorney, can the attorney provide, perhaps walk through how you would justify, say, adding, and we recently, since this bill was announced was going to happen, there has been another unfortunate protest at a Remembrance Day service ceremony. Can the attorney maybe perhaps highlight how, because if we brought this in, let's say we brought this bill in 3 weeks ago, and we would never contemplate that anybody would protest at a Remembrance Day service, how would presumably the attorney would then go to the left, and the Lieutenant Governor and Council would want to add Remembrance Day services as a prescribed facility or a service. How would the Attorney General justify that addition here? Just so we can see how that would be applied.
Attorney General.
Thank you, Madam Chair. I appreciate the member's question because I think we all had a similar reaction to the choice of Remembrance Day at the Cenotaph to make some sort of a point about COVID. I'm not totally sure what it was, other than that the individuals were not possessed of particularly sound judgment generally. The provisions that I went over with the member in terms of the regulation making authority say that Lieutenant Governor and Council has to have regard to that there's a service being delivered to the public, a service of public importance that's related to health, education, safety, or well-being of members of the public. It's a challenging thing to say, but it's true that the bill really is not designed to respond to the Remembrance Day protest. It is designed to protect public access to essential services in the nature of health services and education services and so on. That doesn't mean that there is not a tool available to police in this kind of situation. There is a breach of the peace arrest power that is available to police in a situation like this, where someone is interfering with the use of private property, an amplifier, a microphone that is part of the ceremony or otherwise. There is a mischief charge that is available to police. But it is one of these challenges when you have an event in a public space that people can be disruptive to that. And it's up to the discretion of police of whether that disruption rises to a level of a breach of the peace or not. And So that is one of the downsides of the constraints that have been placed on Lieutenant Governor and Council to add additional sites, but it's also one of the protections, really, that's put in here, that we recognize that this is a significant exercise of government authority, that this regulation-making power is a significant one, and that it needs to be restricted to the most serious and significant cases, someone trying to access an emergency room, someone trying to get to school, these kinds of scenarios.
Member.
So, again, thank you for that. I think that was really helpful in understanding how I wish to proceed with the next series of the next question that I have, and just in terms of with respect to that response and the reality that police have a variety of tools at their disposal, would they not then also, like, I'm just trying to understand how to reconcile that with the idea that the Lieutenant Governor and Council has, I think in the attorney's opinion, some very clear guidelines about it, and maybe questions from the public about those being more vague than the Attorney General has, in creating a prescribed facility as one of the things where a bubble zone may be created. Is it not true that in those other potential locations or instances that we're not going to get into naming because we're not going to create a long list, that those tools that the police have could be used as well, and that then there is justification to limit this bill to exactly what we were talking about, which was COVID-19 protests in front of hospitals and education facilities?
Attorney General.
Thank you, Madam Chair. So the tools that are available for police generally around poor behavior by members of the public vary. So there are some provisions. We talked about the Highway Act. There's the School Act allows a school official to direct someone to leave school property. The challenge, first of all, schools, we know that these protests took place and that there was a real challenge about what to do about it and how to use the School Act and whatever. We didn't want a patchwork response to the approach to addressing disruptions in our schools. We wanted a very clear understanding that anyone who thought that it was a good idea to go into a school and protest and confront the principal and yell at students or whatever, that was not only against the law, but that there were very serious consequences for that. So with respect to other sites, like the example that I've been using is a childcare facility as vaccines roll out for 5 and under preschool age children. There is a possibility of the need to add a childcare site or childcare sites to this legislation through regulation. And, I think when you're talking about blocking access to a childcare site, maybe you could make an argument around mischief. And some of the discussion we've had today is around the requirement for mischief that you prove the intent of the individual, that they had a criminal intent when they were blocking access. This bill does not require that. So it is an easier standard for a police officer to be able to prove and demonstrate that the law has been violated. So there are other tools available, but they're not in the same. So the example that I used for the Remembrance Day piece was breach of the peace. And breach of the peace is an arrest power for a peace officer, but it's not an arrest power that results in a criminal charge or a fine. And in that way, it's different from this bill as well. So there's a couple public policy pieces here. One is that this is we recognize that this is a significant restriction on individuals. So we want it to also reflect that this is for the most serious and important services for the public. They're services of public importance that people need to access for really important reasons. And that to be arrested, face up to 6 months in jail, a $2,300 fine, that what you're doing, what you're interfering with, the service that you're interfering with, is a really grave and a big deal. And so for those reasons, we've put the facilities that we have in the list. We've created the regulation-making power. We put the restrictions on the regulation-making power. And I also want the member to recognize it doesn't include every situation where someone who is opposed to vaccines or whatever is behaving poorly. That there are other tools that police may have to use to respond to those situations.
Member.
Thank you, and I think I'm exhausted. I have been exhausted, maybe. One more question on this. I really do appreciate this exchange because, well, for a lot of reasons. But what impact would this have if this section was amended to include a health services or specifically to public health rather than to just generally to public importance, to bring it, trying to tie it back to the COVID-19 piece. And remember, I was just about exhausted, so I might not have thought through this, but I just wanted to maybe test this once and then I'll stay seated probably.
Attorney General.
Thank you, Madam Chair. So I think that one of the things we've seen is that these individuals are not themselves, in terms of their desire to block access to or intimidate individuals accessing services, restricting those activities to COVID-19 related services. We've seen schools, we've seen, as the member said, a Remembrance Day ceremony. And so to put into this section, to tie it in to say that the services have to be COVID-19 related would preclude later adding a site like a childcare facility to the list, for example. And the desire here is to recognize that there are a wide array of services of public importance that are not exclusively COVID related, that could be targeted and might need to be added to the list without actually adding to them to the list unless it's necessary.
Abbotsford West.
Thanks, Honourable
Clause
Chair.
3.
Thank you. I think we're close to completing Clause 3. Which, one thing arising that, just with respect to the conversation, the exchange that took place and we have had earlier, I just wanted to check with the attorney. I won't ask him about advice, legal advice he received, but maybe I'll pose the question this way. Is the Attorney General was he concerned, or is he concerned that a bill which sought to target behavior relating to a particular issue, was there any concern that that might render the legislation more vulnerable to a constitutional challenge?
Attorney General.
Thank you, Madam Chair. Certainly from and you know, it would be up to a court and to consider all of the relevant case law and the evidence in front of the court to make a determination. Certainly, I felt a lot more comfortable as AG to say the issue here is not that you're screaming about COVID-19. The issue is that you're screaming at a nurse or a teacher or a student. The issue isn't that you're blocking a door to draw attention to your concern about vaccines. The issue is that you're blocking the door of an essential public service, and that targeting only people who engage in those behaviors who are also expressing an anti-government sentiment colors the legislation in a way that suggests, not entirely dissimilar to what the member was raising in terms of the Labor Relations Code, that maybe, you know, we're okay with protests that don't target government public health policy, but are engaging in or intimidating or problematic behaviors around access. We just don't like it when you do it when you're opposed to something that the government's doing around vaccines or public health mandates or those kinds of things, because that is particularly objectionable. So we certainly, personally, I think that makes the constitutional arguments harder. It doesn't make them invalid. It just makes them more challenging, because I think you could present some good evidence that this is a very specific issue that you're trying to target. Our legislation is responsive to the profound pressures that have been on teachers, students, administrators, and school staff, healthcare professionals, people working at COVID testing sites, and so on, and that they are particularly vulnerable to intimidation, harassment right now. They're working long hours and they're doing heroic stuff. So it doesn't really matter, to my mind, what the content of the expression is the person's trying to get across, as much as it does their actions towards those individuals.
Shall Clause 3 pass? Aye. So ordered. Shall Clause 4 pass? Abbotsford West.
Thanks, Honourable Chair. I wonder, can the attorney describe for the committee? My sense is that, amongst other things, what the attorney and the government have tried to do is create a tool that is readily available and can be put to use quickly, expeditiously by a peace officer. So I wonder if the attorney can describe for the committee, if that's correct, in the kind of scenario that we saw this summer with people engaging in activities that would, following the passage of this legislation, be prohibited activities in an access zone. What's his expectation and the government's expectation and hope around how the tool would be used on the ground in practical circumstances?
Attorney General.
Thank you, Madam Chair. So I know I am certain that the member and I have a shared understanding around this, but I'm going to put it on the record, not because I feel like I need to explain this to the member. The operational decisions made by a police officer or a group of police officers that's responding to a demonstration, I'll describe it as, but really a group of people intimidating healthcare workers or blocking access to a hospital or whatever. These decisions are entirely within the discretion of those police officers, those operational decisions, government's expectations and hopes about how something will be used are one thing. The realities on the ground for the police are quite another. And so, and how they would use this tool or other tools that they have to get control of a situation, ensure access, and protect the public is entirely police discretion. So I want to put that on the record because I think it's important. It's not really what the member was asking me. The member was asking me is what are your hopes for how the police would respond? And so my hopes for how the police will use this tool would be to ensure access to services of public importance, that they would use escalating responses as appropriate, up to and including arrest, ticketing, and pursuing, recommending charges to Crown under the Offence Act, if necessary. That they would use the tool to achieve the goals of the legislation, which is to protect access for both workers as well as the public to services of public importance, and that they would do so in an escalating way depending on whatever the situation was that they faced. And I think that the other piece is really more, it's kind of about the law enforcement aspect, but it's really a different part of it, which is that by passing this legislation, that there might be people out there who they're not sure about whether that was the right thing to do or not, go to the hospital and block the emergency. Or there's some confusion that they have about whether that's the right thing to do or not. I don't know how you could be confused about that, but maybe they're just not sure about, telling a nurse that nurse is committing genocide, is intimidating that nurse or not. What we want to do is remove doubt. We want to be really clear about what our expectations are so that people can judge their conduct accordingly. That within this perimeter around this essential service facility, around this facility that provides essential services, very specific, what I mean to say is a service of public importance, that we don't want you to be engaging in these specific behaviors in this area. The law, we hope, will also communicate directly to members of the public, even without law enforcement intervention, that there are certain behaviors that the public of British Columbia, has expressed through their elected representatives, do not want you to engage in because they have now serious consequences attached to them.
Member.
Thanks, Honourable Chair. The tool, as we have established and will reconfirm here momentarily, in Section 7 or in Clause 7 is available to law enforcement agencies and peace officers for the next roughly year and a half to July 1, 2023. My expectation is that the legislation will receive approval from the House through all stages next week. I'm not sure when royal assent is anticipated for the legislation. Can the attorney just indicate for people who might be interested and will, if we are as a society confronted by this again in the future, just briefly explain how the police will be notified that they have this new, once it has received royal assent, that this new power exists, and confronted by that circumstance that it's an option available to them, roughly or generally the process for ensuring they know about the new tool.
Attorney General.
Thank you, Madam Chair. I'm advised by staff that in the drafting of this legislation that there was significant engagement with police, both police forces, the RCMP, Vic PD, Vancouver Police Department, as well as associations of police in the province, 2 different police associations, associations of chiefs of police and another association, we'll have to get the name for the member. And so being involved in the drafting, there were discussions about ensuring that police broadly across the province were aware of this. So I can advise the member of 2 things. One is the police know that this is hopefully coming. And the second is that there have already been discussions about disseminating the information through these police organizations, and the RCMP, of course, responsible for policing a very significant geographic area of the province, and then the larger municipal forces already directly involved in assisting us with ensuring that we provided tools that would actually be useful to police to be able to use on the street.
Shall clause 4, on clause 4, leader of the third party.
Thank you, Madam Chair. Just for some clarification, I may have come in partway through, and apologies if this has already been clarified, but are police currently unable to arrest without warrant anyone found to be intimidating, physically interfering with, or otherwise disrupting critical services as of now? Like, not from this legislation, but does that already exist for them?
Attorney General.
Thank you, Madam Chair. There are a couple of provisions in the criminal code that police could use to arrest somebody. One is mischief, which is when you're interfering with the use of property of somebody else through your actions. And the other is breach of the peace. Mischief can carry criminal sanctions, which could include time in prison or fines. And breach of the peace does not. It's only an arrest power, and then the police must release you once the risk of the breach of the peace is over. So for breach of the peace, the challenge is there's no consequence. There's no fine. There's no potential jail time. It's an arrest power and then a release once the risk of the breach is over. And then the challenge with mischief is that there's a requirement that the police be able to demonstrate intent, that it is your intention to do these things. And also, it goes through the criminal code process, which is different from the Offence Act process. It's not a ticket, which is what this creates. And the arrest power is impacted by a number of different federal statutes that instruct police what they may and may not do on arrest. All of which is to say is there are arrest powers that exist, but they have challenges in one respect or another compared to what this bill is. This bill is not a duplication of existing authorities. It is an additional tool that police provided some feedback to staff involved in the policy and drafting work to advise on the gap that they saw in terms of their ability to use existing tools to respond to the protests that we saw.
Member.
Thank you, Madam Chair. Can the minister explain then how this relates to, say, the Police Act and how it adds additional powers to police officers beyond what exists under their current scope?
Attorney General.
Thank you, Madam Chair. So staff advised me that there are also staff monitoring us remotely. Section 495 of the Criminal Code does include a criminal offense of intimidation. And we're just getting a bit of background for the member on what the case law has required in terms of before someone can be convicted of that criminal offense. This bill is not related to the Police Act, the member asked. So I can advise her there's no relation that we're aware of. And on this specific section, it does create a new authority for police to arrest without a warrant a person who is conducting themselves in a manner described in Section 2. So that is a significant new power, as well as the ability to issue a ticket for that conduct as well under the Offence Act.
Shall Clause 4 pass? So ordered. Shall Clause 5 pass? Member from Abbotsford West.
Thanks, Honourable Chair. Can the attorney explain in general terms the circumstances in which he would contemplate making an application for an injunctive relief under this section, and in including the provision? I'll ask both questions at the same time. And then secondly, in including the provision that would allow for another person to make that make a similar application for injunctive relief. Who is it that the Attorney General contemplates would most likely seek to exercise the power? Is it a service provider? Is it a health authority? Is it a school board? Is that what's contemplated here?
Attorney General.
Thank you, Madam Chair. There are two third parties that we can easily imagine seeking an injunction. One is a health authority. The other is a school district. And in terms of the Office of the Attorney General seeking an injunction, what would a situation be where that might happen? I understand that for some of the demonstrations in September, an organization called the Canadian Frontline Nurses, which we don't understand actually is made up of nurses, but in any event, that they were quite public about their intention to go and protest at hospitals. It is a scenario where if that kind of thing were repeated that the AG may well go to seek an injunction in advance of the demonstration to prevent certain conduct from taking place there. So those are a couple of examples that may assist the member in understanding the authority.
Okay. Shall Clause 5 pass? Recognizing the leader of the third party.
Thank you, Madam Chair. So I'm going to share with the Attorney General the specific concerns raised on this clause by the BC Civil Liberties Association and just ask for his response to their concerns. So they say this section is particularly alarming because this clause seems to override the three-pronged test for granting an injunction set out in RJR McDonald versus Canada, making it easier, almost automatic, for the Attorney General or any other person to obtain an injunction without notice to the other part. They go through the three-pronged test, which I think the Attorney General is quite familiar with. Can the minister explain why this ability to obtain an injunction without notice is needed?
Attorney General.
Thank you, Madam Chair. So the RJR McDonald test, that's the common law test for an injunction. This is a statutory authority for an injunction intending to set out for the court the basis on which the Attorney General or a third party, in the words of the statute, any other person may potentially be granted an injunction if the court sees fit to. This is not a unique or I'm trying to remember what word the member used. Alarming. In fact, this is a common statutory power and provision. It exists in the Medicare Protection Act. It's in the Legal Profession Act. It's similar to Section 48 in the Public Health Act. And in fact, that language informed the drafting of this section. With that, Honourable Chair, I move the committee rise, report progress, and ask leave to sit again.
You've heard the motion. All those in favor? Aye. Opposed? Carried. This committee stands adjourned.